Good day everyone and welcome to the KVV Training Center. Today we're going to be looking at parties to a contract, which is a further training supplementary to our contract law training. Before we look at the parties, let's recap on the 5 requirements for a legal contract. Firstly, there's consensus, in other words, an agreement between the parties. Secondly, there's contractual capacity, which we are going to be looking at today. Then the contract must be legal, it must be physically possible, and it must contain all the necessary formalities to make the contract a legal contract. Before we look at the various parties to a contract, it's first important to distinguish between a natural person and a legal person. A natural person is someone like you and me, someone with blood in their veins and air in their lungs. A legal person is like a company or a CC or a trust. Our baseline for a natural person is going to be an individual who is unmarried. This person is identified by his ID document. In other words, in terms of his ID document, we'll be able to see his full name and ID number, and this is the details that will be captured in the contract. This person can contract unassisted. In other words, they need nobody's consent, they don't need a court order or anything authorizing them to enter into a contract, and can sign any type of agreement on their own. The second type of individual is our married individual. An individual who is married is still a natural person and is still identified by an identity document. But now, because they are married, we need to determine how they are married, if they need to be assisted by the spouse, and what the effect is on any bond registration that they would apply for. There are 6 ways in terms of which an individual can be legally married in South Africa. For further information on this particular subject, I would refer you to our training called Different Types of Marriages under our KVV Training Center. To give you a quick recap, important to note here is that your individual can either be married in or out of community of property, which will determine whether they need the consent of their spouse in order to enter into any type of contract. An individual that is married in community of property cannot act on their own. In community of property means that there is a communal estate, and therefore both spouses must sign for any contract that the estate enters into. That's either for the buying or selling of property or for the registration of a mortgage bond. If your client, however, is married out of community of property, then such a client can contract on their own and can sign either the sale agreement or the bond on their own without assistance of their spouse. A client that's married in terms of the laws of a foreign country do need the consent of their spouse if either they dispose of an asset or if they burden the estate with a bond. So therefore, they can still act on their own and they are the only party to the contract, but they will have to be assisted by the spouse. In other words, the spouse must give consent to the selling of the property or to the registration of a mortgage bond. A person married in terms of the laws of a foreign country who buys a property cash does not need the assistance of the spouse. Spouses married in terms of customary law are legally married if all the requirements for the marriage have been met, and therefore such a spouse will also then be married either in or out of community of property depending on whether they registered and signed an antenuptial contract. Clients married according to Muslim or Hindu law is not regarded to be legally married, and therefore they can contract on their own. Clients married in terms of the Civil Union Act, which allows for same-sex marriages, are also legally married and can either be married in or out of community of property and will therefore either need the consent of their spouse or not if they have registered an antenuptial contract. The next type of natural person we look at is that of a minor. In other words, someone who is not yet the age of 18 years, which is the legal age of majority in South Africa. Important to note here that the legal age of majority is no longer 21, but is now 18 years of age. A minor is still a natural person who is identified by an identity document, or if an identity document has not yet been issued, then by a birth certificate. A minor will always have to be assisted by a parent or guardian when entering into any type of agreement. There's a difference between a minor under 7 years old and over 7 years old. A minor under 7 years old has no contractual capacity. In other words, they cannot enter into any type of agreement and will always have to be represented by their parents or guardian. So the parent or guardian will sign the contract on behalf of the minor child. A minor over the age of 7 years has limited contractual capacity. In other words, they can enter into a contract and they can sign the contract, but they will have to be assisted by the parent or guardian. A child over 7 years old can enter into certain types of contracts without any parental supervision. For instance, if a minor walks into a shop and buys a chocolate, they can do so without their parents' consent, but for more serious types of contracts, they will have to be assisted by the parent or guardian. The question now remains whether a minor can register a bond. In theory, the answer is yes. The minor will be able to register a bond with the provision that the parent or guardian will sign on behalf of the minor and will give the necessary consent. However, in practice, it does not happen very often, as the banks will not grant a bond to a minor who has no income in order to be able to pay the monthly bond installments. Next up, we look at an individual who is an insolvent. In other words, this individual has been declared insolvent by an order of the High Court. This individual is still a natural person who is still identified by means of an identity document. But now we have a sequestration order as issued by a High Court to confirm that this individual is insolvent. Once a person is sequestrated, a curator is appointed by the Master of the High Court, and this curator now has the capacity to sign any contracts on behalf of the insolvent person. In other words, the insolvent person no longer has any contractual capacity to enter into any contracts unassisted by the curator. The effect on bond registration or application. In terms of our laws, the banks will not allow any bond to be registered in the name of an insolvent person, as that person can no longer afford to pay the monthly installments. Then we have to look at an individual who is deceased. This is still a natural person who is still identified by means of an identity document, but now there's also a death certificate that was issued by Home Affairs that will accompany the ID of the deceased person. Once a person is deceased, a letter of executorship is issued by the master that gives power to an executor to act on behalf of the deceased estate. This executor will sign any and all contracts on behalf of the deceased. It's very important here to look at the date of sale. The executor will not be able to sign any contract before the date that the letters of executorship has been issued. So in other words, once a person dies, we'll have to wait for the letters of executorship to be issued, and only then can the executor enter into a contract to sell or buy any property on behalf of the deceased estate. The effect, of course, on bond registration or application is that no bank will give a bond to a deceased person. Just a further note on the date of sale. When someone sold a property and they die subsequently, after the person has died, the newly appointed executor can decide whether to ratify the contract that was signed by the deceased and proceed with the sale. However, there's no obligation on the executor to ratify and accept the contract, and therefore there's always the risk of a transaction not proceeding if the seller passes away before the registration happens in the deeds office. Other types of individuals that we can look at are as follows. Firstly, we can have someone who is mentally incapacitated. Such a person has no contractual capacity and cannot enter into any type of contract. For such a person, a curator will still be appointed by the Master of the High Court, and the curator will have the authority to enter into any type of contract on behalf of the mentally incapacitated person. Then we can have someone who is either physically handicapped or illiterate. Both these type of persons can still enter into a contract if they can understand the terms thereof. However, if they cannot sign the contract themselves, they can do so by either making an X or putting a thumbprint on the document in the presence of Commissioner of Oaths. Lastly, someone presented by a power of attorney. This can be a person, for instance, that is out of the country or not present in the particular province where the document is to be signed. This person can give a power of attorney to someone to act on their behalf. What is very important to note here is as follows. A power of attorney is only valid for as long as the person who has given the power of attorney is compos mentis, in other words, know what it is that they are doing. So if you did receive a power of attorney on behalf of an elderly person, for example, and this person gets Alzheimer's, then this general power of attorney or special power of attorney is no longer valid. And then a curator must be appointed on behalf of that person. As alluded to, you do get a difference between a general power of attorney and a special power of attorney. A special power of attorney will give you special powers just to do one act on behalf of this person. A general power of attorney will give you the authority to do anything on behalf of the person that has granted you the power of attorney. A general power of attorney is also registered in the deeds office and gets awarded a GPA number to confirm to all parties that this is a valid general power of attorney as issued in your favor. Now that we've looked at all the types of natural persons, we also have to look at the legal persons that can enter into a valid contract. The first type of person here is a company. A company as a legal person can either be a PTY, PTY Limited, incorporated company, or a non-profit company. These companies are identified by the CIPC registration documents as issued by the Companies and Intellectual Property Commission. These documents are labeled COR and tells us who the necessary persons are that will act on behalf of the company. In terms of the old Act, these were referred to as the CIPRO documents. The people that will act on behalf of the company are referred to as directors, and they are appointed by the company to make the decisions on behalf of the company and will sign any documents on behalf of the company. The directors, once they've made a decision to proceed with a certain type of contract, will make a resolution, and in terms of such a resolution, they will appoint one natural person or more than one natural person to act on their behalf and sign the documents on their behalf. Here is a list of the different COR documents that can be issued by the Companies Intellectual Property Commission. As you can see, there are quite a few numbers that one needs to look at, but in between these documents, we will find the Memorandum of Incorporation that will tell us exactly what the purpose of the company is. We will confirm the name and the registration number of the company, which is like the ID number of the company, and we will also see who the current directors of the company are that can act on behalf of the company. This is an example of what a document will look like that's issued by the CIPC. In terms of this document, you'll be able to see the name of the company, the registration number, the physical address and registered office address of the company, and we'll also be able to see who the directors are that's been appointed by the company to act on their behalf. The second type of legal person is a closed corporation, or a CC. This legal person is also identified by the CIPC registration documents that is issued, once again, by the Companies Intellectual Property Commission. In terms of the old Act, the CIPRO documents were referred to as the CK documents. Now it's also COR documents. Important to note that in terms of the New Companies Act, you can no longer register a new closed corporation, but existing closed corporations still exist, and if you buy a shelf closed corporation, you can still change the members in terms of that corporation if it's still a valid corporation. A closed corporation is represented by members, whereas it was directors for a company, it's members for a closed corporation. And once again, the members will have a meeting, and in terms of the meeting, they will authorize someone in terms of resolution to sign the documents on their behalf. That will be a natural person that will act on behalf of the legal person in the signing of the documents. The last type of legal person is that of a trust. A trust is still a legal person that can be either an inter vivos or a mortis causa trust. A trust is registered at the Master of the High Court and is identified by the letter of authority and the trust deed that is issued by the Master of the High Court. It's very important to note that one must always look at the trust deed to see what the trust is entitled to do and authorized to do. If a trust deed, for instance, does not allow the trustees to lend money or advance money, then the trust is not allowed to do that. If a trustee does not allow the purchase and sale of property, then the trustees are not allowed to do this. A letter of authority will always have to be the newest one that is issued by the Master of the High Court to confirm who the new and existing trustees of the trust are. A trust is represented by trustees, company was directors, closed corporation was members, trust is trustees, and once again the trustees will, once they have had a meeting, sign a resolution authorizing someone to act on their behalf and sign the documents on their behalf. Regardless of which one of the three legal entities we look at, it's very important to always make sure that whoever is signing the contract has been duly authorized to do so. One must have the proper resolution in place authorizing this person to act. Otherwise, your contract may become null and void. A legal person can also be an insolvent person. A company, a CC, or even a trust that has become insolvent will be declared insolvent by an order of the High Court. Once a company, for instance, is declared as insolvent, there will be a liquidation order that's issued by the High Court, and in terms of the liquidation order, a liquidator will be appointed by the Master of the High Court, who will have the powers and authority to sign all the documentation in order to wind up the estate of the insolvent company. The liquidator signs the documents, they wind up the legal person to make sure that all assets have been disposed of, all liabilities have been paid, and once that is completed, then the legal person is deregistered. Those are all the people who have, in terms of South African law, the capacity to enter into a legal and binding contract. Just to confirm, this is one of the essential 5 pillars in terms of which a contract will be measured to confirm by a court whether the contract is legal and binding. It is therefore very important to make sure that the person signing your contract has contractual capacity and has the authority to enter into this contract in order for this contract to be enforceable by a court of law. For more information on this specific subject, as well as other information about contract law, do not hesitate to contact us or visit our KBV Training Center for further information. Thank you.